Hello, good morning and welcome to Newsfile. This is your most authoritative news analysis platform. And here on Newsfile, as you know, as always, we put Ghana first. I'm your host, Samson Ladi Anyenini. In my introduction today, I take you down to some very brief history of this country regarding judgment debts, which could have made this country into the Europe, the UK, the America that you see. So we set up a judgment debt commission to find out what happens, what causes the judgment debt. And in 2015, a report as submitted by Justice Yao Apau was that one of the causes of the judgment debts as found by the commission was that we had poor record keeping generally. That's how come William gets a judgment debt from us when we don't owe him. Poor judgment record keeping. Then decision taking by Attorney General sometimes to liquidate, things when they don't have to, and when they have to collapse and terminate contracts, and they do it in a manner that does not allow the state to a briefing space. The inability of the Attorney General's department to properly defend the state in court in majority of cases in which the state was sued for acts and omissions of public institutions. So, check this. We had a judgment debt in respect of a case known as the Rockshell versus Attorney General. In 1986, we had gotten into a contract with them and we were to pay 55,000 cedis. In the end, by 2007, we were saddled with a judgment debt of $70 million US. $70 million US. Well, we worked on it somewhat and we got to pay a total of $35 million US. So instead of 55,000, we end up paying $35 million US. And 55, I mean Ghana cedis, just Ghana cedis. Then we had the Delta Foods case. In this case, we bought maize. We needed maize, so we bought maize. And we were supposed to pay the sum of $2 million. In 1998, I must state that. And then we had a judgment debt in the sum of 2 million, just about 2 million Ghana cedis, including interest. This judgment debt was not paid until Delta Foods embarked on execution processes in the United States in 1999. The state was made to pay an additional sum of $4.9 million US. Mark again, not Ghana cedis. We bought maize and they got awarded, we didn't pay, they got awarded 2 million Ghana cedis. Eventually, they got an addition of $4.9 million US that Ghana was to pay. We had the Calf Cocoa versus Attorney General matter. Ghana ended up paying $3.55 million US instead of an amount of 1.8 million. We had the New World Investment and GNPA matter. We owed them a debt of $450,000 in 2004. Eventually, we got what is known as a compromise judgment in 2007 to pay 2.5 million Ghana cedis. Interest alone was over 2 million, which is more than quadruple the original debt. I'll give you just some two more and then we move on. We had the case of the KAE Ghana Limited versus Ministry of Agriculture and the Attorney General. We had a debt of less than 1.2 million. which was the Northern Regional Administration. The Northern Regional Administration was supposed to pay in 1984. It became 549, almost 600 in 2008. I will just pause here and tell you that as we sit, we are told that a committee recommended the termination of a contract which should have cost us $18 million. $18 million. So that we do what? We avoid cost of about 100 million. Not exactly 100, but about $100 million over 4 years for keeping a particular contract in 4 years. So how did we end up with over 130 to 170 million dollars to be paid? Meaning if we had allowed the contract to run its full course, would still have been paying less than what we are now being asked to pay as judgment debt. How did we get there? How were we not able to pay 18 million to stay out of this? 18 million. Now, this is what we are saddled with. Is it a matter of needless contracts plus unconscionable terms, which the Attorney General says is the basis for promise prosecution of NDC ministers connected to the contracts? Can a contract consummated under the direction of cabinet or approval of parliament, or terminated under the direction of cabinet or approval of parliament, make anybody liable for criminal prosecution for financial loss arising from entering or terminating that contract? Is it the contract, the manner of the contract, or the manner of the termination that is costing the taxpayer this much? And yet eventually, nobody may be held responsible for anything. When you hear that the law actually is made for the rich and against the poor, the law is for the powerful against the powerless, you ask yourself again if that proposition is wrong. This morning as we speak, somebody for just not wearing a mask may be getting ready to get into jail. Somebody is cost at this much, but nobody probably will be found liable because of either cabinet involvement or parliament involvement. So, we find out on the show this morning what must happen. We'll be right back to deal with this very vexed matter. You're welcome back. Here is Samson's Stake. Good laws, not good enough. Dr. Mahmoud Bawumia hits the nail right on the head when he tells us a major problem in Ghana is not the lack of good laws, but non-implementation. The Vice President on Wednesday told the National Symposium on the New Land Law that all the good things in the law will be a mirage if it is not vigorously enforced. He charges citizens to, quote, fight the demons and principalities, unquote, they encounter in acquiring and registering their lands. Like many, his joy is that the new law sanitizes and deals with all the known problems. Who doesn't like this good law that compels chiefs, clan heads, and family heads, and all other landowners to establish a secretariat with registers to manage lands using transparent processes and to render accounts? A law that hands 5, 7, 10 to 15 years jail terms to chiefs engaged in fraudulent or multiple sale of land, land guards and those behind them who try to use force or violence to obstruct, intimidate, or prevent you from developing your piece of land acquired with your hard-earned money. A law that ensures you get a refund if a chief or anybody selling land conceals an encumbrance or problem with the land or falsifies the plan document. They pay between 60 to 120,000 Ghana cedis or go to jail for 5 to 10 years. Officials paid to help you register your land get to pay 12 to 14,000 or go to jail for 2 to 5 years if they aid fraud by deleting or falsifying land records, if they issue fraudulent documents, make fraudulent entries, alter, erase, deface, obliterate, or mutilate a land register for their own fraudulent purposes, corrupt purposes, I mean. These will now be done electronically, how you deal with your land. But all these good stuff will remain on paper if the Lands Commission is not adequately funded and the stakeholders, including the police, equipped to enforce the law. A favorite judge, Justice Dennis Dominic Ejay, observes that a bad law that is properly implemented is better than a good law that is poorly implemented. The Rent Control Department informs me that about 72% of the complaints it received in 2019 concern rent arrears. People can't pay. Tenants are compelled to cough up rent advance for 2 or more years, only to be evicted in ways prohibited by the law because they cannot pay illegal extortionate rates and illegally increase rents. But we know Section 25 of the rent law prohibits charging, demanding, or receiving rent advance exceeding 6 months of the monthly rent, even if you gave out your apartment for more than 2 years. This is punishable by up to 6,000 Ghana cedis, or in addition to that, alternatively, up to 2 years in jail. A landlord cannot increase rental charges without permission from the legal authority, that's the department. In fact, before you can advertise your property for rent, you must obtain an assessment certificate by which the department determines if the premises is tenantable or good for human habitation, and the rate to charge, not an indiscriminate charge. A copy of each tenancy agreement must be lodged with the department. Landlords must procure a rent card from the department for tenants in case of monthly or short tenancies. They are to issue receipts to the tenants when they pay their rent to assist payment of rent tax. That's 8% for premises for domestic use and 15% for premises for commercial use. If this department gets this needed attention, it should be able to generate income to improve its facilities and personnel to sanitize the sector and get rid of the injustice many suffer because of accommodation. But what do we see except complete, absolute disregard for the well-intentioned rent laws rarely enforced in this country by the duty bearers? Well, that's my take, and that's your legal light. Next week, we may bring the experts and duty bearers to answer questions about the problems with landlord and tenant and the way forward, including the bigger issue of the housing deficit and affordable housing for a decent living. We'll be right back to get into the issues, the judgment debts. You're welcome back. This is Newsfile. It is your most authoritative news analysis platform. And here on Newsfile, we put Ghana first, as always. And the show is brought to you by the kind that's sponsorship of Bank of Africa, strong as a group and close as a partner. MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. DBS Industries, quality roofing, that's where you get them. Robert & Son, seeing is believing. Waylead, home is where you start. Star Assurance, your solid partner. First Code Management Service, industry, get it right. The New School, knowledge, compassion, leadership. Now, my guest, Benjamin Boakye, is Executive Director, Africa Center for Energy Policy, ACEP. Dr. Theo Echampong is economist and political risk analyst. He has an eye in this area of energy as well. Oliver Baka Vomawo is researcher, University of Cambridge, and has done a lot of things. I'll tell you about them. There's something about him that you probably don't know. Joseph Winful, Executive Chair, Financial Accountability and Transparency, Africa, a former senior partner, KPMG, and Professor Kofi Abochi is Dean, UPSA. And as you know, it's a judgment debt discussion, just judgment debt. But we are forward looking. We want to look at instead of crying over the problems and spilt milk, what ought to happen to avoid some of these pitfalls. Gentlemen, particularly joining us via Zoom, good morning and welcome to Newsfile from Scotland and at the Gimpa Law School, UPSA.
Morning.
Good, Theo. Good to hear you.
Nice to join you.
Great. That's the fighter general. He's been fighting on the on the front of the let's fix the country. Professor Abochi, I hope we have you online.
Yes, I'm here. I can hear you. Can you hear me?
Great. You are very clear. Thank you very much. And as I told you, Oliver was formerly law clerk to the International Court of Justice and International Arbitration Associate with the international law firm Covington and Berlin, where he represented several countries in matters before the Permanent Court of Arbitration. He was law clerk to the president of the International Court of Arbitration. Those of us who are in the field of arbitration, and that's where some of us are pursuing our further studies, we are very familiar with people like this. And some of you may not also have known too much about our own professor, who you find in the judgments. His solid hand, sought after all over the place. Now, gentlemen, before we get to start, and I'll be starting with us hearing the voices of the politicians playing the usual political ball with this serious matter, plunging this country into so much of debt. But before we do that, take a look at this picture and then briefly, let's have your comment about it. Fix the Country has been out there trying to have a demonstration, and it's been near impossible to have a demonstration. In the meantime, we know all the sorts of things that are going on in this country. So look at the picture on the screen. First, on the left, top left, is the president driving through, a place and crowd. This is in the northern region, in the upper region. And this is a crowd of students. And you see, many of them are not even masked, and they are crowded by the president's convoy. And then bottom left, it's a similar situation. As you know, the president has been out there touring the country. Then on your top right, you have the funeral, Sir John's funeral, where people just milled in like that, and did everything that we are not supposed to do in COVID times. And nobody gave an apology for it. The presidency didn't find the need to do that. And then on your top bottom, on your right, that is Fix the Country people who went to court yesterday to, listen to what was going to go on in the courtroom. And the judge gave an adjournment to the afternoon about 1:30 to give a decision. So they came out, and what we are told is that they were standing there taking pictures and doing this. And 15 of them got rounded up by the police, led by Kwesi Ofori. For 3 hours, they were kept in detention. Their lawyers went, talked, and then we are told they have been given bail, even though they have not been charged and there is no condition to the bail. I don't know what kind of bail that is, if there's a new law to institute what bail is in that regard. So these people standing in this space manner are committing crime, and the police can see and arrest them. But in all the other pictures, no crime at all is being committed. What do you say? Barker, start with you because you are interested.
I thank you again for this opportunity to address this question before we go to some of the vexed matters we've talked about. And I think that for us, we have always been very particular in stressing that this whole conversation is about holding a mirror to our society. Because a lot of us continue to live under the false impression that this is in fact a democracy. Now you had a show on I think the law. I've forgotten the full title. You could perhaps remind me.
Yes, it's called The Law. I hosted university students, LLB students, not law school students. Your undergraduate law students who were talking about their perceptions and realities of what the law is. And even at that stage, a lot of them have come to the understanding of the reality of our democracy, that we do have certain laws in place, and the promises we make to the people does not reflect the reality of the implementation of the law and the way in which the law continues to be used to repress certain individuals. And I think that this conversation is something that we all need to pause on. Sorry to interrupt, but you are being nice about what the students felt. They are losing hope in the law that they are learning in the school, because what they are learning in the school, they say, does not reflect the reality they see in the country. And they were unanimous from KNUST, Cape Coast University, the rest of them, University of Ghana. That's the situation we found at Central University. And I felt very bad about the situation.
I felt horrible about it, but I'm not diplomatic to a fault. The fact of the matter is we've been trying to engage institutions, all civic-minded people in this country, as to the reality of what this democracy is becoming. But that is a conversation we are having so much difficulty even voicing out. And it becomes even a self-fulfilling prophecy where we are trying to show what is wrong with the country. And the state is responding in ways which are evidence of what is continually wrong with the country. So I do hope that this becomes a moment where a lot of people wake up as to the fallacy we are continuing to live under. And that this become, a point where we all rally together to save the soul, as I continue to say, or to save the republic from what is becoming, what it is getting to. Because if young people we are training have already lost hope, we have to provide that framework to rebuild that hope in the Ghana project. It's one of the things we've continuously talked about, but it's something that everybody decides to, again, politicize our voices and refuse to engage with the substance of what we are saying. And I'm hoping that a lot of people who are watching this show, and so many people do, take this moment to ask themselves, what is their civic responsibility in this conversation? And what can they do? Whether they want to support or mobilize or fix the country or do it separately. The truth is, there has to be a point where civic-minded people speak up and do something. And I hope that this provides that opportunity.
Okay. All right. So just a very last word from you. So you guys are still going to go ahead and work on doing the demonstration that Fix the Country wants to do, or at this point, you are going to give up?
I think for us, we have always said that even if you're going about pursuing the exercise of constitutional rights, it must be done responsibly. And the first time around on May 9th, before we put out the notice to the police, we sat down with public health experts and they advised us on the basis of what was happening in the country, whether this was the appropriate time to go on a demonstration. And it was on the basis of their advice that we provided a framework for how the protest can be made COVID safe. We had no engagement from the state, which continued to insist to Ghanaians that all open air events was safe, no matter how it was conducted or done, whether with mask or no mask or people in large numbers or not. Now, in this case as well, before we proceed and go for it with anything, we must sit down with those public health officials and determine with them what is the appropriate timing, and how can this be made possible? Because it's always for us about the test of whether the Constitution is still alive.
All right, thank you very much. And Professor Abochi, and Becca, may I remind you that there's a Delta variant, a very violent variant of COVID-19 that is sweeping across. And we are familiar with what has happened in India. Even in some African countries, they are back to full lockdown because of this one. It's killing people in the 40s and hundreds in days. And so we all have to be careful, shouldn't we? Professor Abochi, I understand your peculiar circumstance for which you are speaking to us this morning, but we want to do a brief about this. Then we come to you to give us your take on the judgment debt, and then you could take leave of us. But tell us, what do you feel or what do you see is playing out in the pictures that I put up to you?
Well, invariably, there are contrasting things in terms of how we observe the various protocols, in terms of how we're respecting and observing the challenges surrounding the COVID. Clearly, sometimes the pictures are not consistent in the sense of the messaging vis-a-vis the compliance. I can understand one difficulty, and that difficulty is it seems that with the evolution of the COVID is probably around to stay for some time. I think that's one reality that we probably are not embracing ourselves. And if COVID is about to stay with us for some time, then giving COVID as an excuse both in the judicial decision or giving COVID, using COVID again as an excuse in terms of policy making, these are things that invariably will have to reflect the long-term effects of COVID, which means that we must have adjustment mechanisms that allow us to live our lives around COVID without being reckless, but at the same time without compromising too much the daily realities of our lives. Because otherwise, then we basically tend to be bogged down by pretty much a pandemic that may not be going anywhere anytime soon. It's not an easy picture. It is not an easy thing to deal with on the face of it, because this is a complication the whole world is trying to adjust to. And clearly, I can understand.
What do you say to leadership when we understand, for example, that the Delta variant is already in the UK, and we know that things that happen around the UK get to us in minutes, if you like. What do you have to say to the president when he continues to have engagements publicly that see crowds, when he has issued an executive instrument that bans all of us from trying to do some of these things?
Well, I'm not in a position to advise the president, but I think clearly the messaging must be consistent. And because leadership represents some sort of lighthouse, which we all look at in terms of modeling our lives, the messaging must be consistent in that respect, i.e. things that are said must be seen and must appear to be consistent with things that are done. In fact, people look more on things that are done than things that are said. And I think the president showed exemplary leadership, especially in the initial phase of the pandemic, with constant updates and with a strong messaging on what needed to be done. And we saw consistent government action in the initial phase of the pandemic. But I think that for some time, people have complained, and some of which have been borne out by pictures and the reality of things, that the development or the evolution of the pandemic and the messaging have not been consistent with the actual behavioral patterns of people in government, with the behavioral patterns of leadership. And that's critical, because that can then create fragmented compliance.
Professor Abochi, I am happy and glad that you taught me partly constitutional law, conflict of laws, and the rest of them. And I am glad that you taught me. Now, you taught me that the Constitution provides, and I'm familiar with it in the Bill of Rights, that we are all equal before the law. What do you see happening? The people are getting into places of worship, they are getting arrested. Fix the Country guys are standing at this space of distance, clearly without any harm, in compliance with the protocols. at a court premises where many times chiefs have cases. They come there with a whole lot of their people. Nobody does anything against them, but they are getting arrested. And yet, these people who are doing these crowds, and the president amongst the people leading them, nothing is happening. What has happened to the law you taught me?
Well, I earlier heard you talk of students saying they're losing some degree of hope in the disjuncture between the law in practice and the law in action. The law in practice and the law in theory. I would just like to assure these students that this did not start today. There's extensive literature in the jurisprudence, which led actually to a whole school called legal realism, which is supposed to, which theory was supposed to actually bring out those disjunctures. The fact that the things that actually happen in court do not necessarily reflect legal theory. So this reality has been there. But again, I can understand their frustration because sometimes the disjuncture is so elementary that students are taught one thing in the classroom, and then they go to court or they intern in law firms. And one of the first things that lawyers will tell new interns or new lawyers who join the firm is that, whatever you were taught is one thing. Now we're going to teach you how things actually work in practice. And so that expression, this is how it is done in practice. And lawyers pride themselves in saying, in practice we do this. And I've always told students that expression in practice is actually in some ways an endorsement of the imperfection, i.e. that you are taught something which is very beautiful, but hey, this is the imperfection, and the imperfection is actually what you have to now get used to. It's a sad reality, but unfortunately that is what has been. So I can understand their frustration, but I'm just saying that they should not be overly exasperated about this, because it is not now. This has been there for decades and probably hundreds of years. The reality of the law always trying to catch up with practice. But in Ghana, probably it's a bit more pronounced, and I can understand the difficulty. We all have to work very hard to bridge that gap, gap between good principle and in some ways bad practice.
I must say that a lot has to be done to bring these students and many other Ghanaians who are losing hope and faith in the law and the system itself. A lot has to be done. Because this morning I just gave you some examples going through using the Rent Act, for example. You can't advertise a premises for commercial use as rent without first having the rent control department making an assessment to determine that the building is habitable, is tenantable, is good for human beings to dwell in. Number two, to determine the cost and the charge that you must take from your tenants. You can't advertise it without going through this and getting what is known as the assessment certificate. Who does that in Ghana? We know they don't do it. The law is, held in breach. You can't increase your rent without recourse to the rent control. But we know they increase the rent arbitrarily any day in this country. And what's happening? Nothing is happening. You can't take rent for more than 6 months. People are giving their properties for 5 years. Yes, the law allows it. But they are taking so much. Young people who just come out of university, need a place to lay their head to go to work, are being asked to pay 2 years advance, 3 years advance. Where are they going to get that? And this is happening in this country. So that's part of my issue. And when you listen to the students, you can tell their frustration that there's a lot of work that has to be done. Now, Dr. Tio Champong, Dr. Bochi talks about the president's commencement of the process and his involvement in updating us and everything. Do you think that he has the moral, he will have the moral right to stand before the television and tell people again that they should comply with COVID protocols after all that they are seeing him getting involved in?
Good morning once again, Samson. I think the pictures you showed is just a reflection of the rhetoric and the reality. And in a way, it reflects the fundamental, what I call indiscipline that we have in the society, but reflecting it from top down, because you have, in one breath, the politicians telling us to follow the protocols, but in another breath, clearly what you see is them not actually acting on it. So it's like them saying, do what we say, but not what we mean, and it reflects that what I've been characterizing as rule by politicians, of politicians, and for politicians. And it goes back to some of the fundamental governance challenges that Oliver and a few other civic-minded people have been raising about the issues that we have with the Fourth Republic that we need to address. Fundamentally, the over-concentration of executive power that gives cause to a lot of impunity, which says that we can do what we want to do and damn the consequences, because nobody, after all, can hold us to account.
Ben, what do you also have to say? And you see, when we sat here this morning, I started the show alone in this studio. So I felt I could start without the mask. Now you came in wearing your mask. You're protecting me, more particularly. Then I realized I don't have mine on yet. So I find that I am not protecting you. So from what the politicians and the science people are telling us, the duty bearers are telling us, I am minded to quickly put my mask on. I sanitize and I put it on. If they are making these and they are not complying with it, do you think that the people down there will comply with it and we can compel them to comply? In the meantime, if we don't comply, we are exposing each other to danger.
I think this is a very difficult conversation, especially where those who are supposed to check all of us are not checking themselves. And where you even have to, they can compel us to comply. But the sad reality is that even when you are compelling the people to comply, it comes at a cost to all of us and to the state. So I think morally, beyond the law, all of us leaders, citizens, have to take that responsibility to ensure that we don't necessarily unnecessarily endanger our people. And perhaps that's what is missing, because you can get away with the law, when you're a leader. The laws don't function against the mighty in our context, and that really makes it easy for them to evade the law. But I think we have to keep asking and pushing them to bring back that conscience in them. And I think those who perhaps may be advising the president at this point, he needs somebody who loves him to go to him and say to him that when history is recalled, the people who mobilize for him to do the greetings, the people who encourages him to participate in the violation of the law, their names will not be mentioned. It is his tenure, his time, that will be counted. And I think once that conversation is had, I'm sure he will start processing that. In this information age, you can't easily get away with this kind of violations when history is recalled.
All right, thank you very much. And to all of us, like you said, we have to push. Now, those who sit and try to say we are pushing even to help, more particularly the poor, the majority of these poor people are interested in politics. And so you, the one trying to even push for their rights and for their well-being, they will turn against you because you're speaking somewhat against their party people. Well, this is the only country we have. If the Delta variant is around, we will be doomed. We can't even mobilize the vaccines to vaccinate our people, to give them the least of the protection expected. It is not costly to obey the protocols to avoid a situation where we are supposed to go buy vaccines and we don't even have the money for them. We'll be right back. Engage with Dr. Abochi, Professor Abochi first. He will take leave of us, and then I'll engage the rest of my panel. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. My guest, Benjamin Boakye, Executive Director, Africa Center for Energy Policy, ASEP, Dr. Theo Echampong, Economist and Political Analyst, Oliver Baka Vormawor, Researcher, University of Cambridge, Faculty of Law, very familiar with this area of arbitration, having been clerk to the President of the International Arbitration Panel. International Court of Arbitration. Joseph Winfall, Executive Chair, Financial Accountability and Transparency Africa, and former Senior Partner, KPMG. Thank you very much, Mr. Joseph Winfall, for joining us. All right, Professor E. Kofi Abochi is Dean, UPSA Law. Now, Prof, because of time constraints with you, let's get to this judgment debt. What's your reading of it, and what's it? I'm tired of these things. I've read Bank Switch, I've read Balkan Energy, I've read and volumes of documents. You read, you can't even sleep. And you end up asking yourself, what's all this about? And Justice Yawa Paul, we invest money in him to sit for a long time to look at all sorts of judgment debt, and brings us a report, brings us all the solutions. And yet we are back here, you know, money that is going places that could have developed this country and ensure that the roads we are complaining about would be paved with gold, really. What's going on? What's your reading?
Well, for us to have an understanding of this, we need to put everything in context and avoid probably a particular kind of judgment discussion. Because that isolates it and makes it look like we now have a problem. We don't now have a problem. We have always had a problem. And that problem needs to stop because it is undermining this country. Judgment debt has featured in our budgetary imbalances in the past. And it was actually used to explain one of the reasons why our budget did not balance, which tells you that it has a significant commercial impact on our economic arrangement. It's important for us to remember that judgment debts do not just happen. They happen because of a number of factors. And in the case of Ghana, the key reason here is because state contracting, state commercial transactions are inextricably linked with politics. Therefore, once you have a situation in which the decision to continue or abrogate is contingent on a political consideration, and this has been the case across the political divide, across the political spectrum, where considerations of whether to continue or to abrogate is often a reflection of changes in government. It has almost always been the case in the past till now. Once you have that, you are invariably likely to have a difficulty of judgment debt because the exit clauses in contracts are often, especially international commercial contracts, are often based on minimum thresholds that have to be met. And if your calculations are political, you are not likely to meet that minimum threshold. So the termination clauses in contracts, because the actors thereof, especially the private parties, because they are calculating high commercial things, they ensure that they are adequately protected. Unfortunately, because our calculations often to exit these contracts over the years have been mainly motivated by political considerations, we often do not do the rational calculations that would ensure that we have met those thresholds. So we almost always exit these contracts in breach of the termination clauses. All contracts, national commercial contracts, have exit clauses. They have termination clauses. But if you comply with the termination clauses, you're not likely to incur any judgment debt. If you do not comply with the termination clause, then you would have exited the contract in breach of the agreement, so to speak. So between contracting, i.e. entering into the contract by the state, by a third party, and exiting the contract, the mediating factors often happen to be political. And these mediating factors, which are normally politically contingent, are those that invariably result in judgment debt because the calculations are not commercially rational or legally rational, so to speak. So you have a clear mix of politics and commerce. And when politics and commerce meet, politics loses out once the venue is a judicial one, i.e. a court of law or a commercial arbitration.
Right. So in this specific circumstance, the reports, the committee set up in 2016, we are told it is set up in September, and yet when you read, it starts to sit in October. So the committee report recommended, among others, having found that we didn't need this because it was excess power or gas that we're looking for, it wasn't necessary. Recommended, number one, the government may consider terminating the PPA of the GPGC, that is the Ghana Power Generating Company, executed between government and that company, with an installed capacity of 107 megawatts at an estimated cost of 18 million. So we could terminate it for 18 million US dollars, or else we will be paying excess capacity charge of US dollars 24.90 million per annum over the contract period of 4 years. That's close to, that's 90, if you like, 96 million US dollars. So by what you just said, and from your reading of the arbitral award, what brought us to where we are now?
Well, invariably, you've indicated the recommendation for termination. We have had judgment given against us because we have been said to have been in breach of the contract in terms of our overall conduct. Again, not necessarily specifically just limiting it to this particular case, but everything depends on your calculation of your risk liability or your liability or risk. I.e., if you should comply with the contract, what is your cost? If you should terminate the contract, what is your cost? And in your termination of the contract, your calculation is, if you should not comply with the termination clause, what is your potential assessment of damages in case you are sued in court? So there's something called calculated breach. Calculated breach in contract is what allows the party to make an assessment of his potential overall cost in the event that he has to comply with the contract fully, or in the event that he terminates. And so I'll give a very simple example. A very simple example we give law students is that if you're going to sell a product to someone and the person is going to pay, let's say, $20,000, and another person shows up and says, I will give you the same thing for $100,000. Now, if I terminate the contract I have with that person who was going to pay me $20,000, if he sues in court, the court will not, one, give him the $20,000 because he hasn't parted yet with the money. But the court will give him damages which is equivalent to extra amounts that he needs in order to enter into the same contract with a third party. Plus or minus, the court may end up ordering me to pay him $5,000 or $10,000 more for him to do that. But I may have gotten $90,000 myself. So I simply have to do the calculations, commercial calculations, and then do an assessment of the balance of cost and liability, benefits and liability. And once I think that it balances on the side of benefits, I go with benefits. I basically terminate and go away. So contracting and termination, they're extremely commercial in character. And the question is, who are the people who are making those assessments? Because those are assessments that can be done. There are lawyers whose fields are simply, to specialize in quantum assessment. So they do the assessment of quantum of claims, quantum of damages, quantum of benefits that may be awarded to one party, and the liability that may potentially go against another party. And then they will advise properly on what kinds of steps to take. The issue is not just a committee set up by Ghana, sitting in Ghana, thinking of government interest, and deciding, for example, that you need the subject matter, or you don't need the subject matter, and on the basis of which we are recommending terminate or otherwise. These are assessments that would have to be made from all the angles, and I suspect, and I wasn't there, so I give the benefit of the doubt, I suspect these were done. But if they were done, then the question is, when the decision was taken not to comply with the committee's decision, again, what were the consultations? Who was speaking to who? What assessments were done? Ultimately, did we have a clarity on how much cost will entail us? Should we terminate the contract in compliance? How much cost will suffer? Should we terminate in violation or in breach of the contract? How much cost it will entail if we wait and we don't terminate it at all, and if we allow the contract to run its full cost? It appears to me that somehow some calculation wasn't done or some consultation wasn't complete, and in the process it explains why we're here. But this is the field of contract that has been taught laws to do, and that have been practiced at the highest commercial transactional level in practice, that there are so many lawyers who are aware of this and who could have helped. And I'm not quite sure where the missing link was, which is why something wasn't done, and invariably we have had this additional award awarded against us. But again, like I said, it happens from year to year, government to government, across the political divide in spectrum, and this is something that frankly we cannot allow, and we should not allow to go on.
The Attorney General tells us that the contracts or the agreement was so bad from the start that it invariably, saddled the country with the judgment debt. He says, number one, the contract was needless in the first place. The terms were unconscionable. And on that basis, he is going to commence a process for prosecution of the NDC ministers who are connected to the contract. From where he sits, Clause 1 of the agreement defines the effective date of the agreement to be the date of fulfillment of conditions precedent. Then Clause 2A defines the term of the agreement to start from date of signature. Contradictory for him. Then Clause 2B stipulates that when the agreement is terminated in the course of the term of the contract, a party that is not responsive to a default will claim all expenses made, plus all amounts that arise if the contract were to run its full course, pursuant to Clause 25 of the agreement that fixes the state with such liability. My question to you, can a contract consummated under the direction of cabinet or approval of parliament, or terminated under the direction of cabinet or approval of parliament, make anybody criminally liable to prosecution for financial loss arising from entering that contract or terminating it?
At least from my reading of the law on causing financial loss to the state, that law is not one that demands the establishment of theft, benefit, or other improper receipt by a person on behalf of the state. On his own behalf, but using the medium of the state. That law doesn't contemplate that. That law simply says that you have acted in a manner that has resulted in causing financial loss to the state. And the key operative word is willfully. And willfully means you had discretion. You could have exercised discretion. You had judgment. You could have exercised judgment. You failed. And your omission or your wrongful commission would have resulted in the loss to the state. So if somebody who is supposed to be a high state functionary, who is supposed to represent the state and to ensure that he exercises due care, skill, and diligence, has failed in that regard, by reason of which the state has suffered significant loss, by reason of which the state has incurred massive liabilities for which the state can simply not come to terms with complying, and as a result of which the state has to breach the contract and then suffer the loss or consequence thereof. That person invariably, in my opinion, and these are decisions that only a court can make, but in my very private opinion, that person can invariably suffer the consequences of causing financial loss to the state. Because what it means is that you would have failed to act in a manner which is par. The law of causing financial loss to the state is one that just expects you to act in accordance with standard behavior of doing these things. And you have mentioned all these factors. In international commercial transactions, these are standard features of many contracts, i.e. condition precedents, condition subsequent, i.e. specific things that are supposed to be done before the contract comes to force. The fact of whether the contract has a particular effective date, which often could be tied to the condition precedents, but not necessarily all the time. There are contracts that can start before the condition precedent, because the condition precedent itself is part of the contract. It is a term of the contract that expects you to do something. So some contracts will have an effective date that predates the condition precedent, because the expectation is that once the contract comes into force, the condition precedent, which is an obligation of the contract, also kicks in, which then expects you to undertake the kinds of things that would enable your obligations to be met for the contract to go into full swing.
Okay, so let me ask this way: if the contract is deemed to be the act of cabinet or parliament, if the contract is done on the back of cabinet's instructions, or it is approved by parliament, or it is terminated on the instructions of cabinet or on the approval of parliament, is that the act of parliament or act of cabinet?
Contracts are not entered into by cabinet. Cabinet approval of contracts, cabinet discussions of contracts, cabinet putting together a team to even structure and draft a contract and negotiate and all that. These are administrative processes of cabinet. Contracts are approved by parliament. That's why the courts have decided, and the Constitution has stated, that international commercial transactions must receive parliamentary approval. So once parliament comes in, the contract is not that of cabinet. It is a contract of the state approved by parliament. And so when there are terminations, and that's where the problem is, the approval process invariably is gone through parliament. But terminating processes are often done through executive fiat and through administrative decision-making. It is part of the disjuncture of our constitutional practice that hopefully will cure one of these days. But in the circumstances, the entry process, that one is parliamentary. But the exit process, depending on the character of the contract, very often we've had executive decisions that are taken. And again, this is not...
Can you prosecute an individual for being the sector head when you say that the act is that of parliament through the approval?
Again, very good question. You can prosecute the individual, even though it may ultimately go to the extent of liability, and in terms of, if it's punishment, the extent of punishment. Because the assumption will be that that individual is still employed to exercise minimum diligence and skill. That individual is supposed to play a gatekeeping role. That individual is supposed to play a facilitative and technical role. Ultimately, Parliament is a collegiate body. When these things come before Parliament, it's expected that Parliament will also scrutinize things and look at things very carefully. But the expectation is that individuals who are employed to play the technical, supportive, facilitating role, which normally starts in the ministry, those individuals will do their work well. So when Parliament, if they fail, they have their own liability. Parliament has failed as a collegiate body, or may have failed as a collegiate body, and Parliament has its own, blame or liability, generally speaking, as a body.
Okay, so what would be the liability in this matter where we are told it was a parliamentary approval? What would be the liability of Parliament?
Parliament has no legal liability to speak. Parliament at best will have a political liability. Parliament as a state agency may have regrettably failed. And when Parliament fails, Parliament is the representative of the people.
Let me get a bit of clarity. You are saying if a technical group does work and the approval is for Parliament to approve, regardless of Parliament's approval, the individual will still be held liable? The
individual will be liable.
What is the purpose of the approval then?
No, that's what I'm saying, that there are various levels of responsibility. It is the reason that the taxpayer pays somebody to perform a ministerial, administrative, civil service role. That is the reason. So at that level, those entities have responsibilities, and their responsibilities are not excused merely because Parliament will look at it. Because the logic of that argument would be then, if you follow that argument, the logic of that argument would be then to say that because Parliament will look at it, the work done by lower level officials or ministerial entities are basically irrelevant because Parliament is expected to play its ultimate role.
All right.
There are various levels of scrutiny and audit, and the expectation is that lower levels of officials or other ministerial entities would have also played their role with diligence. By the time it gets to Parliament, Parliament would be there and ready to complete it.
Okay.
But I'm just saying that for constitutional purposes, once Parliament approves it, it is actually a parliamentary law, a parliamentary transaction.
If the Attorney General is exercising their duty or mandate under Article 88 of the Constitution, and they approve a termination or advise it, are they liable in law?
If they approve a termination,
or they advise, because the Attorney General is the advisor of the government. If, in this case, the committee brings a report, Attorney General will advise. Attorney General advise and say, go ahead and terminate. Will the Attorney General have any liability by performing the duty?
If the advice is willful and negligent. Don't you forget
the Attorney General?
Absolutely. Even lawyers are liable. I'm talking about regular lawyers, not Attorney General. Ordinary lawyers are liable for negligent advice.
No, I thought the Attorney General, in the exercise of their duty in this regard by law, is not liable.
I do not subscribe to that view, that the Attorney General has no liability on the basis of the performance of his duty. I don't see that immunity in the Constitution. The Attorney General's role... So
if the Attorney Generals of this country, all the advice they have been giving us, and in the end we find that something has gone wrong, they would have been the one to advise us. Would you hold them liable?
No, that's not it. That's not it at all. A lawyer can advise. A lawyer can give the best of advice which can go wrong. That doesn't make the lawyer liable. The liability of lawyers, and the Attorney General is the lawyer. Don't forget that. The Attorney General is actually, in the scheme of things, we consider him the leader of the bar. So he's the #1 lawyer in Ghana. Now, the liability of lawyers for advice often rests on negligence. It is a question of skill and diligence. So if the lawyer has exercised all skill and diligence, if the Attorney General has reviewed all the documents he's supposed to review, he's listened to all the lawyers he's supposed to listen to, he's done all the consultation he's supposed to do, he's reviewed all the cases among others, and he's done all that a reasonable Attorney General, a reasonable lawyer should do, and the advice still turns out wrong, the Attorney General is not liable. He is only liable if he fails to exercise skill and diligence, and therefore if he acts in a manner that we find below par, as far as a good lawyer, let alone an Attorney General, should have behaved in that particular circumstance. Then, of course, there's a case of liability. So, yes, the Attorney General is liable, just like anybody else, if we have to consider the question of causing financial upset.
Okay, so now let me come to the end of where I brought all these questions. The ministers under the previous regime, the Attorney General under the first term of the President Akufo-Addo, could be liable in what Godfrey Dame is seeking to do to prosecute. Is that your reading?
That's correct. If the principle laid down is what it is, and I stand by that as what it is, then it means any minister, any state functionary who partook in that, if it is established, once again, if it is established that they have acted in a manner which is below the standard of a lawyer, in terms of the advice they gave, in terms of the industry they exerted, in terms of the inputs, in terms of the skill and diligence expected. If they fail that standard,
you are saying that your Ghana law doesn't indemnify the Attorney General for advice the Attorney General gives to the best of their abilities?
If you can clearly establish a case of negligence, if you can clearly establish a case of legal negligence, professional negligence.
Okay, so my point then is that then our Attorney Generals are in trouble, because for almost all of government business, big business, they give the advice, and yet they are never standing in any court for anything.
Well, they do, but something, again, since we are speaking to the public, let's be clear so that people don't get it wrong. The standard principle is legal negligence. The standard principle is professional negligence. If you're able to establish that the lawyer involved, and in this case, the #1 lawyer, the Attorney General, if you can establish that he acted in a manner which is professionally negligent, legally professionally negligent. So that's the key thing. So it's not the fact that the advice turned out to be wrong. The advice can be wrong. You can exercise all the skill, but the advice can still turn out wrong. It doesn't make you negligent. And there are so many advice that lawyers give all the time, which turn out wrong. Once it goes to court and the court doesn't accept it, legally you're wrong on the face of it. But it doesn't make you negligent. It is where we can establish clearly. For example, there's a key law you're supposed to refer to in your assessment and advice, and you did not refer to that law. You did not even research it. You did not put anybody on it to do any research for you. You basically just proffered an advice without proper reflection of what you're supposed to do as an Attorney General. And it is shown that you have acted negligently. There's liability. But there's no liability if you've done all you're supposed to do, but somehow you still got the wrong impression.
And the same applies to Cabinet for the decisions they take?
No, cabinet, these are not lawyers. Remember, we're talking, for the Attorney General, we're talking specific issues of legal liability or professional liability and negligence. But for other ministers and advisors and government functionaries, they have a responsibility to also exercise care and diligence in terms of their functions as state officials. And that will be assessed when it comes to the question of causing financial loss to the state. Because causing financial loss to the state is based mainly on the question of willfulness. And in considering whether or not your action has been willful and therefore wrongful in that respect, the consideration is your exercise of discretion, your exercise of diligence, and how careful you are in terms of management of rural government business.
Thank you very much. So from what you have said, citizens can hope that all these judgment debts that's costing us so much and impoverishing this country over the years, we can look forward to prosecuting the attorney generals, we can look forward to prosecuting the ministers, even though Parliament by Article 1815 gives them the power of oversight over these international transactions and so on. There's some liability at each level, so we can find a way of holding people culpable and perhaps
parliamentary authority does not excuse administrative responsibility. There are two different levels. So the administrative responsibility adds up to the parliamentary process. In other words, it's a quality input process. So if everybody is acting qualitatively from one step to the other, we're going to overall have a very good decision at the end. But if the lower level fails, and Parliament also then fails, then you have a complete failure. And in many cases, that appears to have been the case in the state of Ghana.
Okay. Thank you very much for your input. I wanted to read just a portion of the award and then let you go so we can have the guests, the other guests also continue. In paragraph 479 of the award, it says whether or not Dr. Ahinkra's evidence to the tribunal was correct when he testified that none of the information said by the Attorney General to have been elicited on inquiry of the Energy Commission was provided directly by the Commission to the Attorney General. Rather, all correspondence had been between the Commission and the Ministry of Energy. It is evident on the record available in this arbitration that the premises upon which the Attorney General's advice was founded did not reflect the true facts. First, as Dr. Ahinkra was obliged to concede, the board of the Energy Commission, which was the body charged with approving a provisional generation license, had not been reconstituted when the GPGC had submitted its application in July of 2017. That remained the case at the time that the Attorney General was preparing her advice. Second, GPGC did not have a building permit for the Blue Ocean site issued by the Katamanso District Assembly, and Government of Ghana has not been able to adduce any statute or regulation, including the Energy Commission Act, which addresses the requirement for any additional construction permit. Third, the nature of the GPGC equipment to be used for these works was expressly described in the EPA, and it had been inspected and approved for use by the ministry in June 2015. Finally, fourth, the extent of the interplay between the obligation of the parties so far as their respective conditions precedent and conditions subsequent were concerned has been considered in some detail above. It says the tribunal respectfully disagrees with the Attorney General's advice. It has found that there is no basis for the Government of Ghana's contention that it has established an entitlement to terminate the EPA pursuant to Clause 4. So, my point is, if you read, So my point is, if you read the first part, and Abochi is leaving us, if you read the first part, you will see the question of what the AG advised on. Sorry. And it does appear from what the tribunal found may not have been on the basis of the committee's recommendation. And one of the paragraphs I have been reading overnight for a couple of times also is 490, paragraph 490. It says one of the PPAs recommended for termination was the GPGC project. This is the one we are talking about, which has brought us this problem. Dr. Hinkre's committee suggested that termination could be achieved for some 18 million as opposed to payment of 24.9 million a year for 4 years in excess capacity charges. The basis of that recommendation is not known. The copy of the PPA committee report submitted into the record by Government of Ghana is heavily redacted, notwithstanding the tribunal's order that the unredacted text be disclosed. Under cross-examination, Dr. Hinkra unequivocated as to whether he had any recollection of the particular recommendation made in respect of the GPGC EPA at all, just as he had sought to distance himself from the Attorney General's advice in 2017. Does it change anything for you when it comes to talking about what the Attorney General advised and what the tribunal seems to find, that it is not on the basis of the committee's reports? Okay, I understand we've lost Professor Abochi there, but he had to leave us because he has an urgent thing to attend to. Let me now come to the studio and deal with my guest also on Zoom. But maybe perhaps I should start with Becca on the question of the criminal intent the Attorney General intends to prosecute. And I'm sure for many Ghanaians who are not interested in the politics, they are looking at who will take something, who will suffer something for the wrong that we are all saying has been done. Do you agree with Professor Abochi's views about liability, even upon Parliament's approval, even upon Cabinet's approval, and to come to individual liability, including liability on the Attorney General?
I think to a large extent, there's a lot of things he said that I agree with. But I think that for some parts, he failed to avert his mind as well to the Supreme Court's decision in Balkan Energy versus Attorney General.
Good.
Where the Supreme Court said that the power purchase agreement in that case was not valid unless Parliament had ratified the agreement, which meant that the signature of the minister in that case did not give approval or validity to the agreement itself, but it was the act of Parliament that brought the agreement into existence. So those questions can affect the extent of liability. But it's not to say that liability for even those persons is completely excused, because the extent of the information that was available to Parliament, as for Parliament to take its decision as what comes into question. Because you cannot give Parliament insufficient information and then expect that every decision or step it takes completely insulates you. But it's also the question that he raised, which I think I completely agree with him, which is the level of discretion left to an administrative person, even after Parliament has intervened. Now, the question then becomes, even when Parliament approves an agreement, can a person still, or the administrative person still go ahead and refuse to execute that agreement? And what language do we put in some of these agreements? Let me give you an example. Despite significant case law that exists in this republic with regard to contracting between the state and international parties, we continue to see agreements where the state says the agreement comes into force upon signature. That, for me, entails some level of criminal liability, because you understand that it must be subject to parliamentary approval. And in the Balkan Energy case, it was particularly clear that we had incurred international liability, even though Parliament had not intervened, because of what we had put into the contract. So those questions will continue to come up. Now, with respect to Cabinet, now I think, to be fair, that's an interesting one, because we have never really pondered on the extent to which Cabinet intervention insulates anybody. And I am inclined to Professor Bochi's view, that to the extent that there's no collegial immunity for Cabinet as it exists, and the only person who has some level of immunity is the president, we could, to some extent, still be able to hold certain persons to account, even when cabinet intervenes. And the cabinet's own actions could lead to criminal liability for the persons involved in that. But there's scope, obviously, for the Supreme Court to decide that there's some level of measure that should be extended to cabinet. But I don't want to get into those conversations yet. But I think the bigger problem is procedural. Because we do know that in this case, and when you read the Tribunal's award, you understand that civilian questions were raised about the indolence of the Attorney General in this matter.
Yes, and when we talk about the Attorney General, we are talking about Gloria Akufo.
No, I think we are talking about both Gloria Akufo, but also everybody else who served in Attorney General's department, who was involved in
particularly for the portions I have just read, which is talking about advice. It was Gloria Akufo, not Godfrey Dame.
So let's make something clear here.
Yeah.
I work in the office. I work in the legal office of the United Nations. A lot of times, everything that is signed in the name of the legal counsel. But it does not mean that the lawyers who work on it were necessarily the legal counsel. And I think that has to be very clear. Because we are not expecting that the Attorney General herself or by himself, despite being head of a department, would draft every legal opinion. He or she is part of the legal decision.
Yeah, but there's ultimate responsibility, and in this case,
I agree.
In this case, yes. I am emphasizing to single out properly what ought to be. In fact, what the Tribunal talks about, it has no connection to the present Attorney General. Please go on.
So this is one of the things I want to say clearly in this matter is that even in the legal team that represented Ghana, Godfrey Dame, who is Deputy Attorney General, was mentioned as one of the counsel for the respondents. But I don't want to make this about him. I do think that he has said that he wants to go and initiate criminal investigations and prosecutions for persons involved. I think that the proper thing to do is to appoint a special counsel. We can think about the special prosecutor. I do not think that their act allows them for the full scope. But he can appoint a special counsel who would be given fiat, and he can step aside and make the process transparent and independent. That the person would investigate the entirety of the matter and determine from the signature of the contract, from the abrogation of the contract, from the defense of the legal claim, which persons are liable.
Right.
And those persons would be prosecuted. I think that's the proper thing to do. If not, you put it into a partisan realm, which is not mature and responsible.
Right. So the law that regulates the Attorney General's department and their work gives the Attorney General power to appoint a lawyer to be an independent prosecutor of a particular matter. That's what you are saying is the right thing to do, right?
I think that's the right thing to do. People need to step aside. And we've seen examples of this, for instance, in the US, where the Attorney General then, Attorney General Sessions, was presumably involved in something that could have affected him and the president. An independent person was put in place to be able to investigate the matter.
Right.
And I think that's something that we need to do in this case.
It is not a situation where our laws are lagging in that regard. Our law clearly states and empowers the Attorney General. So you say this is the best way to go. All right, thank you. Now hold on, let's move away a bit from the legalese. And then people are hearing, of course, what brought us here is what is said to be the breach. That we committed a certain breach as a country to the contract. And once we committed the breach, the people decided that's where we find ourselves. What is the breach that we got into?
Well, thanks a lot, Samson, and regards to my colleagues on Zoom. I think we really essentially didn't pay attention to the contract in totality and proffer a solution to what we deemed to be an excess capacity that needed to be abrogated. Because the contract is specific and clear what you do.
That small bit, forgive this rude interruption, that small bit about excess capacity. Somebody in my village in Gambivgo, in the Upper East region, is asking me, what's this excess capacity people are talking about? The light doesn't get to all of us. So what is the excess you are talking about? Because not all of us have lights.
So electricity, in the electricity system, you plan your demand to coincide, your supply to coincide with your demand. Anything beyond that has to be paid for, even though you may not need it.
Okay.
So here you are thinking about your infrastructure to extend the electricity across the country, what the timing for fixing the infrastructure across the country to be able to wheel a certain amount of power. So if you estimate that this year you can do 3,000 megawatts and you have 5,000 available, you obviously have 2,000 in excess of what you can actually supply to the market. But because you have contracted them, you necessarily have to pay for that excess, even though the one in your village cannot access it because we don't have the grid lines to them. Somebody has to bear that liability.
All right, so please continue. Thankfully, my village, there's lights. Yes. We just need to get together and get the poles, and then we get the light. So you say we didn't pay attention to the agreement. Explain.
No, I think once the agreement came into force, all right, the condition precedent had been fulfilled, and the agreement kicked in. The contractor obviously would have started delivering on his responsibility. So the conditions subsequent, if you read the agreement, much of the burden was on the state. That has to do with acquisition of licensing, EPA, and the rest of the...
That's only facilitation.
Yes, so we committed to facilitate. And I have had problems discussing this with the politicians. Because when you do that, what you're essentially saying is that the Energy Commission that we have established to regulate licensing, the EPA that we have established to regulate that wherever a plant is sited is environmentally sound for that to happen. Any other institution that has a function relative to an agreement, the state says, I will let them give you the license. So if you go to Energy Commission says, we cannot give you the license for ABCD reasons, they are compelled to give you the license because the state will be held liable for not complying with this commitment in the agreement to provide the license or to help them get the license. So for the conditions subsequent, we were to help the contractor to deliver those. And if you read the judgment, it was clear that we were negligent. We just went to sleep. We were pretending we didn't know we had conditions subsequent for which we can be held liable.
Agencies were fighting among themselves.
They were just, moving around, playing games, and not paying attention to what the potential liability could be on the state. All right, and that is where we are, And I think we come back to the advice that were proffered, which landed us into this. And I think, if we had paid attention to the contract and understood our liabilities, we wouldn't have cancelled it. And it's quite intriguing in this particular case because I've read some advice that the Attorney General had given, even before this one. And I thought she'd been extremely careful with similar agreement. Particular case would be the Ameri one, where she stated that you could not cancel that agreement, all right, and you just need to negotiate with the contractor. That same template could have been given in this particular case because the terms are virtually the same. The same responsibilities on the states are the same. And if you cancel, you are going to face the same liabilities. And so that is where it gets intriguing that we gloss over what the contract was saying, and we are now being told that the Attorney General relied on the advice from the committee. And I find that very odd because it was about interpreting an agreement to see how it conforms to whatever advice somebody was giving to the Attorney General, and not to consume the report of the committee that sat. And I have problems even with the report of the committee itself. I don't know how they came by the 18 million. It was alien to the agreement. How they calculated that, I don't know whether they were involved in the importation of the equipment and knew how much had been spent. I've been trying to find out whether they even engaged.
Yeah, but that's what they did. They were looking at the issue of early termination,
yes,
where there was mobilization and demobilization. I brought my equipment, it cost me so much, even though the equipment belongs to them. And that was very clearly stated. And they have to remove equipment or something. All of these things cost money. And if you read through the judgment, it was found that the mobilization, some $40 million US involved in, all sorts of things. So they came to the conclusion that you terminate it that early, then you could do that at $18 million US.
But early termination is defined in the agreement, and it states that you pay 2 years of the contract sum. So you cannot sit in your comfort because you have been appointed as a committee member and say, instead of 2 years, half of the contracted period, we can only pay 18 million. That was not for them to
So
decide.
this committee also ill-advised?
I think they should have just stayed with an advice to engage the contractor to terminate. And that could have involved.
Well, Chiejako says he was acting on, directions, cabinets, and all of that, and he couldn't vary whatever it is. So the best decision, we're dealing with excess capacity. We didn't need them. It was going to saddle us in the end by 4 years. Would have been paying a total of 996 or so. No, just about, I like to round it up to about 100 million US dollars. So whatever it is, from where you sit, we could have terminated it in a way that would not have brought us to where we are.
Absolutely. I mean, so that the same point. If you have to terminate an agreement, you have to go to what the agreement says. And then you deal with it from there. If there are any concessions that the contractor wants to make, by realizing your difficulty, the fact that you have excess capacity, the fact that you cannot consume the power that is going to come from that plant, those are things that you can always negotiate. And I think there was always the room for government to have engaged the contractor and negotiated. In fact, some of the contractors were even deferred. So why was this one not deferred? And these are some of the questions that we
So as far as you are concerned, what is the main problem? Is it the contract and its terms, or end the termination?
I mean, both. The contract and its terms, and also the termination. I have said that the nature of the contracts we signed in the power sector, and even generally, gives so much to the investor. And for good reason. You may not like it, but because of some of the reasons that we are here, where an institution pretends they don't even know what is happening. So the investor need to cover all tracks to ensure that this behavior doesn't lead to a loss. So we sign agreements that makes us liable for a lot of things. And that's also because we are not developing a market-based system
let's
where we
go
could
to
allow...
Zoom. I'll speak to Theo Echampong, I'll speak to JoyNews, and then we have Henry Yamson. But you see, everything that's going on, I like the Kofi Abochi optimism that somebody eventually would be held liable. But the reason I kept asking him was that I know what the law appears to say, which doesn't seem to support entirely what he said. In the matters of the Balkan Energy and the rest of them, Estin Cubic matters, we are familiar with them. And the Supreme Court says, where an agreement must get parliamentary approval, that agreement is not valid until the parliamentary approval has been given. So, if it is the approval that gives it validity, I am thinking it's possible that people will run away from any liability because what they did was not valid. It is what Parliament approved that was valid. So if you have a problem, go to Parliament. And our MPs, clearly, we know what goes on over there. They do the political game, they sleep on the job. Once it is NDC in power, everything from the cabinet or executive is fine. No NDC person will oppose it. Once it is MPP in power, everything from the cabinet is fine. No MPP person will oppose it. I mean, sometimes you ask yourself, what's going on? The people who are there, can't they exercise a little bit of independent minds? Okay, so Dr. Theo Echampong, in the circumstance where Dr. Komna Donko tells us about the circumstances of this case, where he says that we got this in the best of terms, and we're not even going to establish an LC, we're not giving a dime up front, and they were to do almost everything. From your reading, would you say this is a lopsided agreement in the circumstance that we didn't have money to give them to do anything, but they had to do everything up front?
Look, I think at the end of the day, a commercial agreement is a commercial agreement, and there are terms that both parties are bound to follow. And I'd like to reiterate what Ben said, that we did not do a thorough enough work. In fact, we went to sleep after signing the contract, and we were expecting the party to have followed through on most of the conditions subsequent, without realizing that we needed the actual state to facilitate, like, licenses, etc., etc. So eventually what that then happened was that the so-called 45 days between the signing of the contract and, the things being delivered ended up being pushed forward and forward and forward, down the line. So we cannot absolve as a state or as a government ourselves of responsibility in causing this harm in the first place. And it shows various levels of failures along that, governance value chain. And I think realistically, this whole idea about prosecution and so all of that, I don't think it will come to anything. It will come to naught. Because of the way the political system and the governance structure and things work, like, I am inclined not to believe that anybody would actually be prosecuted on the basis of, whatever has happened. But we will end up paying the money anyway. Now, going back to the point you started me off with what Dr. Kobna Donko said, we need to understand the decisions that were made within the circumstances of the time. You had a power crisis, citizens were up in arms on the street, there's doomsday, you need emergency power, so you go and negotiate those terms of the agreement, however bad they may or may not have been. But at the end of the day, we committed ourselves to ensuring that the work is delivered. And when you read the agreement, it's very clear that GPGC did some work. And they did some work up to a point that you now say you're going to cancel the contract. But the cancellation of the contract is now on the basis of this technical committee's report. And like Ben, I have very serious concerns about some of the numbers. So for example, the 18 million, nowhere in the report, when you look at it, they establish or give us a basis of arriving at 18 million as the early termination fee. When you factor in the work that the company has done and you read the letter and spirit of the agreement, clearly, if we terminated early, we're going to pay much more than that. And if I were advising then, it would have been to find a way to actually renegotiate the terms or maybe even push it forward, just like we've done with a number of the other contracts, rather than canceling it outright. Because here we're paying $170 million, but not a single megawatt of power has been added onto the grid. And you come back to that fundamental question of professional negligence, not being thorough enough with the work that we do, especially within the various institutions. But whether or not somebody will be prosecuted on the basis of that, I'm quite skeptical.
I see. Do you think there would have been a better way?
I think the better way it would have been to try and push the contract and the commissioning date slightly ahead, or further into time, and try and bring, the other party to have some form of settlement. I think the government took a very hardline, legalistic stand, and even the basis or the legal basis for terminating the contract, when you read it versus the reality, which is that the guys had done some work, and if you're going to cancel it, you have to compensate them fully for the work that has been done. There was a disconnect between that position and the reality on the ground. So I would have actually either two options: ensure that the project comes to commission, or try and push the commissioning date slightly further ahead into the future. Because then what that means is that you may get the power, but here we are in this particular instance, the outcome is that we don't have any power, not a single megawatt, and we are paying $170 million.
Interesting. Let me go to Joe Winfo. Thank you so much for your patience also. What's your reading of this award? Needless or what?
Yes, Ladi. Well, anyway, I must say I commend the panelists who have been sitting with you because I've enjoyed all the legal, wrangling. Let me take you back, a few. I just came back last night, and whilst away, I interacted a lot with the Ghanaians in the diaspora, and these are Ghanaian professionals, who have so much commitment to being citizens, even whilst outside, and taking care of themselves. And I think we have a basic problem. You remember when we started crying for democracy and the rest of it? We started looking at the areas of democracy, human rights, this and that. We realized that we have attained, a lot of these other principles, the human rights and so on. But we had neglected a major component which will push the democracy forward, and that was financial management. And that was the basis of coming up with the Fat Africa and so on. I also remember very well that during the time of BCRC Crab and Professor Jando, we had discussions at the CDD. It was part of the conference, and it was related to the constitutional review. Now, I realized that all the comments and the discussions were based on the law and this and that and that. And I raised an objection. I said, look here, every little item you mentioned here has financial implications. And it looks as if we have detached this financial, requirement from our democracy and thinking so far as you can write anything in the papers, so far as you can stand on the mountaintop and scream and criticize a government or an individual, you have democracy. That is not the case. What we've been discussing or what you've been, being explained about this, has an underlying principle we've got to tackle. Is it caused by our culture? Is it caused by, incompetence? Is it caused by the governance structure we have in place at the moment? Because it looks as if the word merit has been omitted from our vocabulary for the simple reason that all these contracts being drawn, and we call them lawyers, we call them professionals. For God's sake, we even had subcommittees. I read part of it with subcommittees on the technical side, subcommittees on the legal side. I mean, were the agreement not written in English, which is a requirement of every professional to understand and comprehend what is going on? I've been sitting here listening and saying, this must be a tip of the iceberg, and this is the power sector. What about the water sector? What about this? Maybe if we are very, very diligent, we'll be able to slash our public expenditure by more than 40-50%. And that is going to improve our development. I know we've been sending missions to Rwanda, Botswana, and the rest of it to see their governance processes and structure. Did we learn anything from it? Or do we come back, organize workshops and conferences, and just jaw around it and come out with a nice write-up of the summary of this and becomes academic? I even heard in the diaspora that Rwanda and the rest have been taking up a lot of lessons from Ghana. They come to study. That's right. And they wonder why we sit back and do not, implement it, but talk a lot about it. It's pathetic. I was trying to instigate a public discussion on what Dr. Jonas said, Sam Jonas said, about what is going on and our governance and our depletion of what needs to be, sustained.
And I said, oh my God, it means that, one, for those who can talk, I mean, I was glad that he was able to come out. And instead of taking it as a national topic for discussion, sometimes there were a lot of bashing. So I could understand why a lot of people sit back and say, well, you know, this too shall pass, you know, which is a shame. And I said I am associating myself with the last condition upon which one can talk, which is apart from being Gandhi, which one is not, and Rockefeller, which one is not, or my doctor has not said I have 2 days or 3 days to go, so hopefully a few more. But when he said we are at the threshold, that is at the point where we know we'll have to look back and see whether we've left any legacy. Maybe that is the, you know, the area I fall into. So I'll say, have I contributed a bit? Have I even done a little bit to improve the lot of my fellow Ghanaians or whatever it is? And you sit back and you're saying, you know, it's your voice that you can use. It's your action. But maybe, is it enough? And are the right people hearing the right word? Part of the discussion we had in the diaspora was, you know, about our selection of our political leadership and then the political structure, the way it is, and the political investors who come in as business, you know, investors and dictate what needs to be done so that they'll be able to recoup their investments and so on. We touch on all of that. I'm very familiar with some of these judgment there because we at KPMG were involved with one of African countries that at the end of the war, you know, had huge amount of claims that had to be, but they did not do just the arithmetic or, you know, relegate that to the law courts. But they asked for, and I think USAID or, you know, helped them to actually ask for validation of the claims.
Okay.
We had to undertake validation, and I'm glad and proud to report that we won the contract, although it was international bidding, and we had to undertake this, which took us months and months. Okay. But at the end of the day, we rejected about 80% of the debt with so much evidence that, you know, people could go to court. I even encouraged some of them to go to court and give them my address, that they should even add my name and not those ones. Right. So I realized that we actually are glad in accepting some of these claims, which, you know, result in judgment there, so it becomes a legal matter without looking at the base. But in validating them, we had to look at the value obtained from the contract, the processes that were adopted, and other factors. You know, and right. I remember very well, too, that during the time of President Mills, late President Mills, he raised the issue of claims and so on. And, you know, even mentioned that he was going to get the accounting firm to come in and, you know, review some of these. But when the request for proposals came, I told my guys we are not partaking in this because it was to do arithmetic and not really to validate the essence of some of these claims.
All right. Okay. Thank you very much, Joseph Winfo, Executive Chair, Financial Accountability and Transparency, Africa, and former Senior Partner, KPMG. Thank you so very much for your time this morning. Right, and you see, he speaks and suggests other things, speaks broadly and generally about some of the issues. And Justice Apau, for example, in the sole commissioner's work, found among other things that these contracts, some of them, were actually influenced by corruption. I'm not saying this is what this one is, but he said, for example, why he recommended the need for certain things to be done. He spoke about political campaign funding bill. He says the commission recommends that Parliament passes such bill with urgency. This is because the funding of political activities and election campaigns has become a major source of corruption in public office. Party patrons sponsor candidates to become members of Parliament and presidential candidates. Others are sponsored to become metropolitan, municipal, and district chief executives. When such candidates succeed in winning elections or get appointed, then it is payback time for the patrons. This is usually carried out under dubious contracts, which lead to unlawful abrogation of existing ones. And the contracting parties that suffer such ordeals normally end up in the courts, where they manage to secure undefended judgments against the state. In most cases, after the abrogating authorities have exited from power, such judgments carry heavy penalties, sometimes factitious. There seem to have been insidious systems of corruption permeating public life, especially at the local government level. Thus, a political campaign funding bill is required to stem these sources of corruption, which in the long run generate debts to the state. So this is a body we set up with constitutional powers, and it examined a lot of, dubious judgment debts, a lot of them. Most of them, the Professor Mills administration had inherited, and the debts was piling, and previous governments had not paid. Now, because previous governments had not paid, those debtors, those who got those judgment debts, sought to take hold of our installations, maybe our embassy, high commissions elsewhere. They seize all sorts of things, they garnish our accounts, and then government is almost, grinding to a halt. Then it forces us to now begin to pay. And within that period, the government was looking to pay these monies that had been sitting on for a long time, averaging some $500 million US, $500 million US for just a few of the judgment debts or contracts that we had abrogated. So as we started, I read to you something. I just want to look at that again and go to Henry Yamson to take his view. Now, in what was known as the Rockshell versus Attorney General case, in 1986, we were liable to pay $55,000. Now, we sat around it, we didn't pay, and then in 2009, they eventually obtained a judgment debt of $70 million US. And I had mentioned to you 55 Ghana cedis, rather. Now, we were caught up to pay $70 million US. And eventually, we had to pay $35 million US, $35 million US, instead of 55,305 Ghana cedis. This is what the politicians have been taking this country through. We had the Delta Foods matter, where we were supposed to pay a sum of 2 million, just 2 million and some coins. Eventually, because we're not paying and we're delaying, the people took up the matter and got an additional sum of $4.9 million US. Now, check how it goes. Some small amount in Ghana cedis, then we end up paying millions of dollars in judgment debt. Then we had the Calf Cocoa versus Attorney General matter, where the Ministry of Finance was to have disbursed the sum of $1.8 million to the calf cocoa, and then we didn't do that. In the final analysis, the state ended up paying $3.55 million instead of $1.8 million. We had a New World Investment versus GNPA. I can go on, and it's ridiculous to think that we have people who say they are leading us and they are working in our interest, and this is what they end up saddling us with, and then continue to go out and borrow pittance. They borrow pittance in the name of helping Ghana, and we are told that the president had to fly in luxurious jets because he's going to bring us money. How much did he bring? How much are we going to pay? Okay, now let's speak to Harry Yamson, a management consultant. Thank you so much for joining us. What's your reading of this, and how can we get out of this ridiculous stuff?
Well, good morning, and thank you for inviting me. And I've also very much enjoyed all the submissions from Prof. Oliver Theo and Mr. Winful. And let me say good morning to those who are also joining us to listen. For me, there are four things that I think are missing, and my colleagues have touched on a number of them. The first for me is the absence of rigor in managing the contract termination in a manner that was legally sound. But more importantly, I think there is this absence of an understanding about the implications for our financial and reputational position in the world of finance and commerce. Ghana is also in need of establishing its creditworthiness. And part of that depends on how well we respect contracts. Now, if we are displaying year after year after year that we have a penchant for putting in place dubious contracts, or we have a penchant for dubiously terminating properly, if you like, agreed contracts, neither of this helps us in terms of our creditworthiness. Neither of this boosts Ghana's reputation in the world of international finance and commerce. And so that lack of rigor, no one today is able to tell us very clearly that this is what it was that had to be done to ensure that in terminating this contract, we did not suffer loss to the extent that we have. The chairman of the committee, as you have read, has distanced himself from the report, has distanced himself from the Attorney General's advice. That doesn't bode well for us. The Attorney General, as I have heard him speak on radio, has made it very clear that he was not involved. The minister who made the recommendation to Cabinet has said, well, it was his job to advise Cabinet, and whatever Cabinet agreed, it was done. So everybody is passing the hot potato. And at the end of the day, it simply tells us that we don't have rigor. We need to have rigor, and I know that we have all in different ways touched on this. The second point and the related point is that
before the second related point, I wanted to mention that as a matter of fact, those who are playing political ball with it, we can ignore them completely, because we can read the judgment for ourselves, and we can read the content and the sufficient, information that exists there.
Yes.
If this attorney general, and I'm hearing some people already suggesting with the usual political thing that why am I trying to insulate this attorney general? I'm not the one trying. That's the documentation. This attorney general went to defend Ghana in the judgment, and then he didn't succeed. So when we try to bring him in at all costs, what are we seeking to achieve? And in fact, the advice of the former attorney general, which was discounted, so which was found to be not based on the committee's report, there is information that clearly shows that advice was given, the termination was done, the government appears to have thought that the termination was wrong or that it will cost us too much, then sought to have the termination sort of renegotiated so that we settle the matter. But our legal advisor at the time didn't seem to be interested in renegotiating the whole thing. And that's why we are here. Otherwise, this matter would have been settled. Yes, please. So. Yes, go on to the second point after the lack of
so the second point then is this issue of a single point responsibility. We have a decision to make, and the decision has an outcome. And that outcome has implications for us. Who is ultimately responsible? As I've listened to you and I've listened to this matter, is it the Parliament? Is it the Cabinet? Is it the Minister? Is it the civil servants? There's a whole locus that is being discussed. And we can't say that ultimately there's this one officer appointed by the president or in office serving as a public servant who is responsible for this decision. That also is not good. It ought to stop. It has to be possible for us to say that in this matter, there is a single person who is ultimately responsible for ensuring that there is rigor, for ensuring that the decisions are done and made in a timeous manner, and that Ghana is protected in all things. That is missing. It doesn't help that people are able to go into this process with an expectation that they are in some way going to be insulated. That also is not helpful. My third point, government itself has not been humble. It has not been humble to accept that arbitration simply means, the result of the arbitration simply means that something has gone wrong. And that grave mistakes have been made. What are these grave mistakes? Because the mistakes relate to how we went about terminating the contract.
Right.
As to whether the contract itself was sound, it's a matter for us to determine internally. But the arbitration is now an international matter.
Right.
So we need to separate the two. There's a homework that we must do in making sure that if the contract was not sound, it should never in the first place have been signed. But now that we have gone to arbitration and lost, we need to accept how it is that we have lost. Because this is a standard that is applicable all over the world. We cannot say that this arbitration will not affect us. It is an international standard that has been arrived at, which we cannot appeal. Or we did not appeal. Whatever options we had, we didn't take advantage of. So now it stands. So we need to accept, okay, these are the errors that have been done. What has happened is that we are having a debate that is always on the verge of becoming political, and it ought not to be. This is about protecting us going forward. If we want to have a political discussion, if we want to have, a not objective conversation, that's our choosing. But I think that every Ghanaian would want an objective conversation that looks forward and says, this is how we are going to protect ourselves going forward. The other last thing that I for me is missing is this resistance to focusing on auditing the actions, first of all, of the cabinet itself, second, of the officials that were involved in the termination process. It's number one the number one thing we should have done when we came back from the arbitration, so that any question that is asked, at least we will be able to say that in such and such a time frame, we will know what went wrong. Because the arbitration already says that things went wrong. But I would say one positive thing. Look, in other jurisdictions, the equivalent of our parliament has a supporting mechanism that allows it to rigorously interrogate matters of budget, matters of contracts. I don't think that we are spending enough money to resource our own parliament to do its work well. If you go to the US, they have the Congressional Budget Office. It is non-partisan. It is able to evaluate whatever proposal comes to it, or sometimes even proposals in advance of what the executive will bring to it. And they advise the legislature in a dispassionate, non-partisan, completely transparent manner about what is in the best interest of the country. Now, Cabinet takes a proposal to Parliament. all the work, and Parliament is depending entirely on the work that is presented to it by the executive. Parliament, in my view, is not well resourced to, independent of the executive, analyze and judge for itself the quality of a contract that has been put before it. So I think that going forward, we also need to think about helping Parliament in its work with respect to making sure that it has independent resources that will allow it to more rigorously discharge its oversight responsibility. Right. Then I think we can begin to hold Parliament more accountable politically. Because, we are not going to be able to hold Parliament as a body responsible legally. But we should be able to now say that, look, you have everything that you need to do the job well, and you have not done the job well. Those are the things that I would say are the gaps, but also what I think we can look forward to putting in place to ensure that we help government as a whole, but in this case, the legislature, to better discharge its responsibilities.
Right. And the Judgment Debt Commission, Judge Sapau's work, confirms basically everything you are saying. And the point you mentioned of auditing was isolated, and giving focus that there was a need to empower the Auditor General properly and its departments all over to be able to do the auditing that you are talking about. They actually suggested also a national debt management policy so that there is a certain coordination. You don't have disjointed conduct going on from various places, and then later people get to find out that we are getting into debt because somebody has done something and has not done it right. So thank you very much for that. Let me go to Berka. Now, Berka, as we speak, the conduct that appears to lead to judgment debts, and for those who believe that particularly this one, the manner of the termination is the problem, or some unlawful conduct is the problem, we are in a situation where we are not having the judgment debts ending. They keep coming. We were slapped within the same time that this one was going on in arbitration. We were slapped with $1.088 billion in the West African Gas Limited case. $1.088 billion US. Look, when I read these things, I don't get what is going on. I don't get what's happening, because when we went to Sino Hydro, how much did we go for? And then we mortgage our entire, future fortunes to it. What are we doing with, we say, gold minerals? We are using an Ejapa to mortgage everything up front. For how much? And yet we are causing all of this. I mean, please, let's be frank about it. This is crazy. But somehow, let's say thankfully, we should still thank the politicians. The Attorney General was able to negotiate to get us to pay only $68 million. The Attorney General refers us to a debt that we're going to be saddled with of 1.3 billion cedis. That's locally, about the NDK case. Because we had done a contract, and he says that contract was for just 268,000 Ghana cedis many years ago, and we're not paying compound interest. There are those who say how we came by the recent judgment is bizarre, but the point is that there is 1.3 billion cedis we're going to pay as a result of a loan that we took of just 268,000 and didn't live up to our responsibilities. Now, here's my point. As we speak, we know that a company has gotten a judgment debt of $15 million just last year, arising out of government's unlawful actions leading to missing excavators. Please underline that, excavators. The time to appeal that judgment is over. But the Attorney General is assuring us that he will find a way cognizable in law to appeal on procedural grounds to overturn it. What are we seeing? Everybody is saying, apart from some elements in government, everybody is saying the way you are dealing with excavators is unlawful. Some people in government say, get off. You would find later that somebody has gotten a judgment debt. So we are not learning, are we?
You know, I wonder if it's a question of refusal to learn or deliberate attempts to defraud the state. You know, some years ago, before I got into Harvard, I wrote a piece for my admission, which is about judgment debts becoming constitutionalized money laundering.
Oh.
Because this is the only thing where once the award is given, there's no way in which it can be challenged. It becomes clean money. So we are using this as a framework to defraud the state intentionally. And this is something which we need to talk about. And it's something as well Justice Apau's report hints at. And I do think that in this particular issues that are happening now, there's also related to that a failure to professionalize even international arbitration at the AG's office. So for everything dealing with the international, we tend to scavengers, like foreign law firms parachuting in to make millions of dollars at the expense of an impoverished Attorney General's department. And that's a question which Justice Apau reports again addresses the need to have this. So almost every year we are dealing with international arbitral claims, and we treat it as if it's the Accra raids, that whatever happens, oh, it's an act of God. We could never have predicted it. But no, the government is becoming more and more involved in commercial deals every time. And these claims are only piling up. Now, let me give you an example of two things that the award talks about that directly affect governmental conduct and connects with the Apau report. About this one, one of the questions the government raises is the questions of confidentiality. And paragraph 84 of the report talks about it. And that's the reason why they were refusing to release the PPA report, the AG's advice, the cabinet memorandum and cabinet decision, which was being requested by GPGC. And they said that they were willing for the tribunal to take any adverse inferences that it wanted from this. But if you were being properly advised, under Article 3.8 of the IBA rules on taking evidence in international arbitration, Article 54 of the WIPO arbitration rules, even the ICC own arbitrations, first of all, you have what they call a confidentiality advisor, who's somebody who can be independently appointed, and where you make your proposals as to things which need to be blanked out. And then they would look at it, study the reasons, and give their own independent one. And then they'll give the reasons to the tribunal and to the other party, who can also raise questions about that. Or one of the things which the ICC itself in arbitrations have done is that there are several instances where it has limited the disclosure of documents to the tribunal itself and to only the counsels involved. A lot of times they sign a confidentiality undertaking. And when the arbitral award comes out, you see that several parts of the report which were vital to the reasoning of the tribunal, but which should not be disclosed, are redacted. So there are several ways in which this could be even addressed, but you don't say that I would refuse to do it on my own, and you can draw whatever inferences that you want to draw out of that. So if you were concerned about the potentiality, as the government claims it was concerned about, of other legal suits that could arise from its own conduct, then these were mechanisms that were open to them that they refused to take into account.
Okay.
The second thing, and this is something which if you do have a professional legal practice and people who have built competence in international arbitration, and not that every year in and out you go and take a foreign lawyer, completely discontextualized from the historical facts and the circumstances of your government to give you advice based on that matter, you would have already put in place protocols to deal with these instances, because public institutions and governments have dealt with this problem forever. I'll give you another example. In Guyana versus Suriname, there were questions around state security.
And before you go to Suriname, you talk about how we bring foreign, guys in this area, and they are unconnected, may not be, do things with a certain patriotic spirit. Yet our country doesn't lack, these
expertise. It doesn't lack competence at all. It doesn't lack Joe, who I worked with at the Constitution Review Commission.
Yes, Professor Albert Fiajo
of many years.
Yes, Professor Albert Fiajo is sought after the world over. And
you have Phil Chikata, for instance, who had an impressive legal brain who was working in these issues.
Yes.
You have Augustine Kidisel.
Yeah.
Some of them were on actually supporting the other side through Kimathi.
Yes, the Ace and Commerce, they are here. They are here. And this is their area. But this is where we find ourselves. Get to the Suriname, and I want to ask you whether you think that we should not also be questioning the terms of this contract, particularly if you look at the clauses 1, 2A, and then 2B, going to 25. Yes, go ahead with the example you are going to give.
You know, now you have even whetted my appetite. I'll leave Suriname for now, because even that concerned questions about confidentiality was protected. And I come to this very question you have asked me. I was involved in a foreign law firm in Covington when I was working. When we have an MA, mergers and acquisition deal, we have lawyers with a significant expertise in different practice areas. You have regulatory and compliance, you have international tax experts, you have domestic tax experts, you have international arbitration lawyers to negotiate the clauses, choice of forum, and the rules of forum. You have constitutional lawyers and administrative lawyers when you're dealing with a public agency. You have intellectual property lawyers. Then you come to the subject matter lawyers themselves. Before you come to private equity, debt structuring, and the quantum assessors that Professor Abochi was talking about. So every aspect of the transaction is micromanaged by persons with expertise in that direct area. It is not something where you have one single lawyer look at it, just our lawyer looked at it and then the contract has been negotiated and we are good to go. I gave an example in the beginning that despite years of saying that you cannot conclude a contract and say it takes effect from signature, we have done that. And that has cost us, even though we know that constitutionally Parliament must be involved in the process. But yet we continue to do that. And the AGs has not set out any protocol for how contracts should be negotiated or even how they are signed for any of the other ministries' services. That is a huge problem. You cannot put in place an interministerial committee to advise you on a legal document for whether you should cancel it or not, which is serviced by one lawyer whose legal life was lived chasing bail applications or land litigation, and then says, we have arrived at an 18 million conclusion, and that's the way to protect the state. You have failed in the fundamental duty of protecting the state. So that's one question that we need to talk about in respect of the question you have asked.
So when you talk about the lack of protocols to be set up by the AG, for example, to govern this, some glimmer of hope. I don't know what you think about it. One of the deputy attorney generals, Dina Asunaba Dapa, this is her area of comfort in these ADR matters. So what will be your expectation of her as she gets in there?
You know, Diana is someone I know very well, and I think she's, and I'm happy for her nomination, and that she's coming into the office. And I do think that if in terms of institutionalizing practice at the AG's office, that she leads that role and putting that in place. Because like I said, we are going to be involved in so many more commercial arbitrations. And especially that we have developed an appetite for foreign ones. We never use our own arbitration even in these clauses. Then these matters are continue to happen. But I want to give you an example that is also tied to this particular issue and also Justice Apal's report around documentation. When you pick up the award, there's something everybody may have missed. Every other person, and even our domestic lawyers, used institutional email addresses to receive correspondence. Gloria Akufo, gakufo@gmail.com. Godfred Adami, godfred@adamilaw.net. Helen Ziwu used private, all of them use their own private email addresses. So how do you institutionalize documentation practices in a public institution? So you see, it's not about blame laying to individuals and then we turn it about, but we have failed to put in place structural institutions. And even in the Attorney General's announcement or the myriad of interviews he has given, he has not talked about those institutional steps that must be put in place. He has not talked about the Justice Apal report and what they are going to do with regard to it. And those are matters that should concern all of us. Because if we play this partisan game again, and then everybody is steering their head, who should it be? Kwabena Donko? Should it be Jaco? Should it be this? Then we say we don't know. Then we wake up, then we leave it. It's going to happen again.
All right.
So that's sort of my thoughts on that.
Right. And as matters of fact, when we were dealing with this matter, we used local counsel. We used Amofa and partners. I read the documents and I find Kimathi somewhere in there, and I find one or two others. But I think it is when we were going to attempt the near impossible appeal that we now began to use this English and is it French lawyers, so on, and that cost us quite a bit, and yet, if you like, they didn't seem to, some at a point seem to have slept on what they had to do, and then we couldn't go forward. All right, thank you very much. You are still here watching Newsfile. This is your most authoritative news analysis platform. We will take a quick break and return to canvas looking forward. How do we get these guys to stop hemorrhaging our country this way and asking us to applaud them for whatever they do in the end? We'll be right back. You're welcome back. This is Newsfile, so most authoritative news analysis platform. Let's get to Ben Boakye and Dr. Theo Champong to commence the last words that they have to say about solutions. As we speak, the Minister of Finance has been telling us that between 2017 and 2019, he has paid in excess of, is it 283 million Ghana cedis in judgment debts, with some that are outstanding in excess of almost like 500 million that is sitting there to be taken care of, among others. So this must stop, definitely. But again, as a matter of a point of fact, Baka Godfredami informs me that since he became Attorney General, and I have confirmed that since he became Attorney General, the email he uses is godfred.dame@Ministry of Justice and Attorney General's Department.gov.gh. Eslausu Ekufo has been insisting that these things be done. Let's hope that they will actually do it. Then we don't get to another point and start talking about just talking and not doing the work. Okay, so what do you think we can do? Justice Apau spoke about a permanent oversight body. That's what they recommended, a permanent oversight body. If I may just read that, then we hear you. It says, finally, the Commission strongly recommends a permanent institution like the present Commission to play oversight role in the handling of judgment debt cases. This organization will coordinate all government institutions that are involved in the handling of judgment debt, including the Attorney General's Department, the Ministry of Finance, the Central Bank, the Controller and Accountant General's Department, the Lands Commission Secretariat, the Auditor General's Department, and all other institutions that are involved in judgment debt cases to ensure efficiency and transparency in the payment of genuine judgment debt by the state and its agencies or institutions. Again, this institution or body would have to investigate all default judgments, consent judgments, and judgment on admission entered against the state institutions via the Attorney General to verify their authenticity. There's a reason he's saying this, that institution would have to investigate all default judgments. Remember, Uyome? All consent judgments, remember Woyome, and judgments on admission entered against the state institution via the Attorney General to verify their authenticity before payments are made. Because some of these, they had found from some of the judgment that some of them are a collusion with even the lawyers who are supposed to protect the state, colluding, you know. But when this happened, some lawyers that were found to have done things wrong and were supposed to be punished were only transferred to some part of the country. They were never really punished. This country, the rules governing this institution or body should be such that it will be devoid of bureaucratic traumas. This would ensure quick and speedy determination of such issues to avoid delay in the payments of genuine judgment debt against the state. Yes, Ben.
Yes, I think another body or another bureaucracy perhaps will be useful for the short-term understanding of what we are dealing with. But the bigger fix, you know, into the future really will be to strengthen the structures that has to deal with some of these commission and contracting, on behalf of the state. So on this particular case, I don't know if there's room to engage the contractor. I think the first step will be, how do we engage around dealing with the contractor himself, who we owe $170 million, to see whether there is even a possibility of saving $1, $1 million, $2 million.
That is always possible.
Exactly. So that is our first call. That's what we have to do. And that's what I want to hear the Attorney General say. Somebody is claiming $170 million from you. What are you going to do to ensure that we don't pay that much? All right, the plans are here. Is there room to defer it, negotiate and pay a certain minimal amount and allow them to generate power into the future for us to consume, of which we'll be able to pay for consuming without paying $170 million for virtually nothing. And
for the
also,
170 figure,
yeah.
I'm very bad at mathematics. I struggle to pass it for my WASI.
It's a round figure.
Yeah,
it's around 174.
Yes.
But the fact is that
I have tried to do the calculation, and it doesn't give me that exact figure. When I do everything, I add the cost and the interest. It takes me to around 160 thereabouts.
About 164.
So, okay.
But 164 at the time of trying to appeal now.
Right.
Mind you, is growing as you're not paying.
Thank you.
So we could probably even be more if we did the calculation today.
Okay.
So round figure 170, we can work with that.
And like we have seen the history of judgment debts, if we don't quickly take care of it,
yes,
by the next year or two, then we'll be seeing that we are paying maybe double the amount.
Yes, because you have interest rate 6% plus LIBOR, so
right.
It's growing by the day as you're not paying. But fundamentally, I think we can fix this by allowing institutions to work and holding people accountable. We were at the point of recounting what ministers sign, requiring that these institutions don't function, but they only take what has been agreed in contracts, and also having the trail that we can use to hold some of the institutions accountable. For example, the committee that actually looked at the supposed excess capacity. If I had my way, there are people and institutions that were on that committee that I will not let them represent on it. Because you have ECG on the committee, you have Energy Commission on the committee, you have GridCo on the committee. And these are institutions that are supposed to plan the power sector. And they should know at any time what our demand is and what the projected demand is, for which reason we are sourcing new machines or new plants, and inform the ministers whether we need more or we do not need more. So at what point do you advise them to sign more contracts, and then you turn around to advise that we cancel or renegotiate the same contracts? So we need to hold people accountable and then have a system that traces what decision everybody takes along the chain. Okay. If we did that, we'll be able to help let these people, individuals, account for their actions, what advice they gave to a minister, at what point did the minister decide not to take the advice. That is where it becomes relevant for you to now go down to see who can you hold accountable, who can you punish for the decisions that have already been taken. And I remember clearly what happened in this space. And that is where Professor Abochi's position about our ability to hold Parliament responsible or Cabinet responsible become extremely curious. Because when we did the analysis around 2005, and we indicated that the possible excess capacity was going to cost Ghana around $300 million a year. All right? Nobody listened. We had presented to Parliament and the rest of it. They didn't listen. Yeah. It went to 600, and guess what? It took the World Bank to tell government that you need to act. Meanwhile, they had the advice locally.
Right.
And we kept pressurizing them that
advice
you can't.
That is even at free.
You can't continue signing.
Consultants dollars.
Absolutely. And it was going to cost us this much. Nobody listened. Fast forward, we have a new government, and you are telling the government that the decision now is to see which one has taken off, which one hasn't taken off. How can you renegotiate and ensure that you can cut down the cost? We sat back and waited for plans to arrive, and now you want to cancel. So we really need to hold people accountable and be able to trace how decisions are made. Right. Otherwise, we will keep going back in circles. And we'll have to pay.
Dr. Theo Champong, what do you have to also say in looking the way forward? You see, there's one thing also a good friend of mine has a lot of concerns about. We have the policy-making institutions, like the ministries. They are supposed to be in charge of policy and oversight. But you find that they take over and supplant the implementing agencies They take over their job. So all the money that should go to these implementing agencies that have the expertise, they starve them, you know, and then take over for whatever reason. I know I won't say. What is going on?
It's just a reflection of the political economy. And you know, we know this very well, where the ministry holds more power and things that, in fact, they're even becoming implementing agencies rather than policy coordination agencies. But it reflects the governance challenges and the weaknesses that we have with institutions doing the work that they're constitutionally mandated to do, because the politicians sometimes just don't allow them to do that work. I think going forward, like others have reiterated, we need a lot more professionalism and, you know, a much more support. But I just want to narrow down to Parliament, because I think the work of the committees in Parliament is extremely important. Most times they review these agreements and, you know, would make a recommendation before it comes to the plenary. I have had cause to engage with some of the committees, and frankly speaking, most of them were out of their depth. They didn't even understand, you know, the issue. So a lot more kind of capacity building or training needs to go in there. But importantly, at an institutional level, I support what Harry was saying earlier. I have been calling for this for the last 6 or so years about the need for an independent sort of office for budget responsibility or congressional budget office type entity that sits in Parliament and can do the kind of detailed, rigorous work that is required, and their report will now accompany any transaction that comes to the plenary for it to be passed. So what that does is that you have an additional layer on there that would support or complement the work that the respective committees would have done. But leaving it just to the committees to do the deliberation and the discussions, I'm afraid it just doesn't cut it.
Interesting. And the parliamentary oversight thing that we talk about, the law is that once they are supposed to approve. If they don't approve, there's nothing that is valid. Yet, look at this particular contract. As we know, there was no question on this agreement on the floor of Parliament.
It has always been. There are so many other agreements you will go and look at, and some we've been here. Some have gone under certificate of emergency. Some of them would come and they are just rushed to rubber stamp. It's just the way politics has been done in the last, couple of years in this Fourth Republic.
So these MPs, don't they know that we are watching and we are following what they are doing, where they're acting as stooges and being plain unnecessarily political about things, appearing as if they can't exercise independent of thought about the things that has to happen?
If any institution can hold the executive to power in the Fourth Republic, it is Parliament. That's where I think a lot of us in civil society advocacy need to push or put a lot more emphasis on making sure that Parliament actually does its work devoid of the undue pressure that sometimes comes from the executive. And not until we do that, some of these problems would unfortunately become part of the reality.
Okay. Harry Yamson, if you're still with us, in a minute, what would you like? Okay, we've lost him, but Becca is still there. And let me announce to you, those of you saying this red herring about the registered offices of the company, please keep us out of that crap. What would you have to say to close?
I was going to talk about the congressional office as well that Theo mentioned, but I would change it differently, and perhaps this is a personal experience about the people we need in these places as well. It's not by accident that I ended up spending my whole life in public service in Ghana before I left and started working abroad. When I was a young man in Morocco, as a student in Morocco, I first met Ambassador Kobnanan, who was the Ghanaian ambassador to Morocco, who took a liking to me and started inviting me to all public functions there that was held as a representative then. When he left, he recommended me to the next ambassador, Ambassador Kote, then. And when I came to Ghana, unknown to me, Ambassador Kote had written to the Ministry of Foreign Affairs asking that they look out for me. So I was invited to the Ministry of Foreign Affairs to be engaged with, and whether I was interested then at the time of even doing my national service there. And so this is how my journey, and I didn't end up doing my national service there, but this is how my journey with the ministry began. When they were recruiting people, an email was sent to me to go and write an exam, and there were 5,000 people there who wrote the exams with me before I was brought into the Ministry of Foreign Affairs. I think we need to be methodic in looking out and headhunting individuals in forming a team. Ghana has the expertise, and we can't do this process. In my whole life, even in private service, I've always recommended people I found at the University of Ghana School of Law who are of a certain caliber to individuals to bring those people on board. And I think public institutions have to have that attitude as well. So because it shapes individuals and it shapes careers of people that we can build a professional practice.
Thank you so very much.
That's my last words on the issue.
Thank you so very much. And what you mentioned, guess what? Justice Apau actually speaks about it, training, mentoring, headhunting people who have the expertise to get them to assist. My guests have been Benjamin Boachi, who is the Executive Director, Africa Center for Energy Policy, and they have been very helpful all of this week explaining these matters. Well, like prophets, they started talking long ago, but we didn't listen to them because, of course, they were giving the advice for free. We have paid consultants, and yet this is where we are. Dr. Tio Echampong is economist and political risk analyst. Oliver Baka Vomawo is researcher, University of Cambridge, Faculty of Law. He has also served as law clerk to the president of the International Court of Arbitration. We had Joseph Winful, Executive Chair, Financial Accountability and Transparency Africa, and former Senior Partner, KPMG. We had Professor Kofi Abochi Dean, UPSA Law School. And then, of course, you have heard Henry Yamson, Management Consultant. Thank you all so very much for joining us on Newsfile. God willing, next week we'll bring you another edition